I rise wondering if the...
is this to debate for a second time?
No, Mr. Chairman, I have not debated the bill itself yet,
Okay.
and I rise to ask if the good gentleman, a good senator from Ford would yield to
Senator Getty, would you respond to an inquiry?
Mr. President, I will.
Senator LeFavour for the inquiry.
Thank you, Mr. President. Thank you, good senator. Could you list for me the conditions under which the continuing or grandfathered contracts could be terminated or not honored?
Senator Getty.
Mr. President, good senator from 19, the conditions would remain the same as they are now under a continuous contract with the grandfathered renewable contract. There's no change in the property right between the two contracts. It's just a change of name.
Mr. President, might
Senator LeFavour.
Senator yield further?
I will.
Senator Getty, would you respond? Senator LeFavour for the inquiry.
Under this particular piece of legislation, I understand there is a reduction of force provision that makes permanent some emergency provisions that we had created previously. And these are lasting. These are not temporary, and there needs to be no declaration of financial emergency from the state or from district in order for there to be a reduction of force.
My reading of Mason, section 114, indicates that debate in posing a question is improper, but rather instead only sufficient facts being stated to couch it. What I'm hearing being offered now are comments about the legislation and beyond the appropriate definition of allowable debate under section 114 of Mason's.
Well, Senators, I would also urge you to read Rule 35, which sets the parameters on what an inquiry could be. So, Senator LeFavour, it needs to be an inquiry about a point that you do not know the answer to and not part of debate. If you want to debate the bill, debate's open. You can debate the bill. So continue, Senator.
Mr. President, though, I believe the section that I'm referring to may have an impact on those continuing contracts and may change whether those are vulnerable now to being terminated under those conditions. And I just want to affirm or to make sure that I understand that, because that would affirm that the good senator had stated previously that it's the same as it is now, and I believe that there is a change under this new reduction in force provision that would terminate those.
So, Senator, do you want to give some specificity as to your inquiry to Senator Getty? So.
Certainly, Mr. President. Good Senator, is it not the case, though, or am I misunderstanding that under the new reduction in force provisions that contract could be terminated?
Senator Getty.
Mr. President, good Senator, I'm on page 15, line 16 through 18. In the case of a reduction in force, it says without consideration of employee seniority or contract status. So, Mr. President, the good senator is correct. The type of contract cannot be considered in a reduction in force.
Mr. President, one
Senator
further
LeFavour.
inquiry about perhaps another situation that may also...
Senator Getty, would you respond to another inquiry? Senator LeFavour for the inquiry.
Thank you, Mr. President, and good Senator. I'm curious in the provisions that also on page 15, where a principal may determine whether or not to accept an employee assigned to their school, if that employee had some sort of continuing contract, would it then not in some way also violate the contract for them to be rejected by a school?
Senator Getty.
Mr. President, good Senator, the principal has the opportunity, if provided two names, of choosing one. If he has only provided one name, he has no opportunity. He picks one. Whether it be a continuous contract or a first-year teacher, that's the instance. I don't see where that would be an infringement on a continuous contract or a property right.
Mr. President.
Senator LeFavour.
To debate against the bill.
You have the floor.
Senators, when we have situations where we have someone with a continuing contract sitting somewhat in limbo, they've been assigned to another school, they may be one of two people assigned to another school, but one of them, and maybe both of them have continuing contracts, have been assigned to a new school, and that principal is going to choose between the two. All of a sudden, one of them does not have an assignment for the year. They may have no employment for the year. In my mind, that is a pretty vulnerable continuing contract. I want to say further that now, under the other types of contracts that every new contract employee will get, there are very few provisions that will remain in place to protect that individual from the politics of districts, which we're all familiar with. The politics of districts are sometimes really uncomfortable ones. A quality teacher will sometimes have impressive rigor. They will be demanding of their students. They will grade their students accurately. Sometimes a difficult thing to do, especially when you have you have the mayor's daughter in your class. These are difficult things that teachers have to do. Yet, under these new provisions and these very, very weakened contracts, districts then will be able to eliminate teachers from their jobs under a variety of circumstances. That assurance and that academic integrity that comes with continuing contracts will be completely lost. So, for example, a teacher who is forced to teach difficult topics, who has great rigor in a curriculum, which makes them perhaps unpopular to parents because there's a great deal of work. Or perhaps those difficult topics necessitate talking about natural selection in a science class. It means talking about difficult issues in a health class. Some of those may be things that parents are not comfortable with, that certain school board members are not comfortable with. And yet now, there will be an open season on those teachers who have to do those difficult things in classrooms every day across our state. Now, I want to caution that further, in very rare circumstances, I would imagine and hope, but under these new provisions, what you will see is that there could be situations where a school board may be of a predominant political philosophy. And there may be teachers who are not of that same political or even religious philosophy or background. You may have differences in many types of things between school boards and teachers. There is nothing to assure us in this legislation that teachers will not be vulnerable to the prejudices of school boards. This is the last thing we want. And I challenge those who support the bill to show me where we will not have that occur in districts and with kids who count on these quality teachers, these outstanding teachers, to be there and not to be vulnerable to these sorts of politics. Thank you, Mr. President.